Good morning. This is your Kelso Report for Thursday, September 1st, and I'm your host, Clark Kelso. Well, in the field of antitrust, cases involving movie theaters and movie distributors have carved out a special niche all to themselves. The competition for your entertainment dollar is fierce, and it frequently crosses the line from fair competition into unfair and anti-competitive practices. The 2nd District got a taste of this in its decision yesterday in Flagship Theaters of Palm Desert versus Century Theaters, which was a typical David versus Goliath story involving a single location theater, Flagship Theaters of Palm Desert, against the Century Theaters behemoth, a national chain with several thousand screens. Flagship's only theater was located 2 miles away from one of Century's theaters. Now, the lifeblood of any theater is the number of first-run movies it is licensed to show. Take away the first-run movies, and business goes elsewhere. For many years, the Flagship Theater and the predecessor to the Century Theater were granted what is known as clearances from film distributors, which amount to exclusive deals with a theater to make sure that the two competing theaters do not show the same films at the same time. The complaint alleged that before Century purchased the competing theater in 2002, distributors granted roughly equal numbers of first-run films to both of these competing theaters. After Century purchased the theater, distributors licensed roughly 3 times as many first-run films to the Century Theater as to the Flagship Theater, and the films licensed to the Flagship Theater were generally inferior films that were expected to generate far less box office revenue. Flagship ultimately sued under federal and state antitrust laws, alleging that Century was engaged in an anti-competitive scheme to leverage its national market power in order to destroy Flagship's business through an unlawful practice of circuit dealing, which the complaint alleged violated the long-standing antitrust law requirement that films be licensed on a theater-by-theater, film-by-film basis. The trial court granted Century's motion for summary judgment, finding that Century did not have sufficient market power in the relevant local geographic market to cause competitive harm, and that Flagship could not demonstrate antitrust injury. The 2nd District reversed. First, on the question of antitrust injury, the trial court concluded that Flagship needed to demonstrate an actual lessening of competition in its market before it could show an antitrust injury. The 2nd District correctly rejected this interpretation of the antitrust injury requirement. The requirement that a plaintiff show antitrust injury simply means the plaintiff must show that its injury results from anti-competitive aspects of the defendant's conduct. The requirement is intended to make sure that the plaintiff's injury results from anti-competitive effects, and not from other factors, including pro-competitive conduct. After all, successful competition will itself cause economic harm to weaker competitors. The antitrust injury requirement is thus used to distinguish between economic harm resulting from increased competition and harm resulting from anti-competitive conduct. However, the antitrust injury analysis does not require a showing that the defendant's conduct has actually resulted in a lessening of competition, which is what the trial court required. According to the 2nd District, the defendants have not introduced any evidence, or really even tried to argue, that the plaintiff did not have sufficient evidence to show that its losses resulted from the competition-reducing aspect of the defendant's alleged practice of leveraging its market power to increase its share of first-run movies. So the trial court erred in granting summary judgment on this basis. On the issue of market power, the trial court erred by focusing its attention too narrowly on the small geographic market in which plaintiffs and defendants' theaters competed. This narrow focus led the trial court to restrict plaintiffs' discovery to conduct and market power only in that market. This focus misapprehended the nature of the plaintiff's circuit-dealing claim. In a circuit-dealing claim, the theory is that a theater's circuit's use of monopoly power in certain locations is used to acquire exclusive privileges in a city where the circuit has competitors. Under this theory, the plaintiff should have been permitted broader discovery into Century's competitive market position in other markets to determine whether it had sufficient power in those other markets to leverage that power in the local market where it was competing against the plaintiff. Given these rulings, the Second District reversed the summary judgment in the defendant's favor and remanded for further proceedings. David has been given another chance to do battle with Goliath. And now our one-liners for today. First in the civil rights area, in Lockett versus Erickson. The Ninth Circuit held that a defendant's plea of nolo contendere to a misdemeanor DUI charge in California does not result in the defendant being barred from filing a Section 1983 action against the officers who allegedly unlawfully entered the defendant's house without a warrant, at which time they arrested him on the DUI charge. Under the so-called Heck doctrine, named after the Supreme Court's decision in Heck versus Humphrey, a district court must consider in the 1983 action whether a judgment in favor of the plaintiff would necessarily imply the invalidity of the conviction or sentence. If it would, the complaint must be dismissed, unless the plaintiff can demonstrate that the conviction or sentence has already been invalidated. In other words, the Section 1983 action cannot contradict the judgment in the prior criminal action. Because the defendant in the criminal action had pled nolo contendere and did not challenge the legality of the search, a pro-plaintiff judgment in the Section 1983 case would have no impact whatsoever on the criminal conviction, and the Ninth Circuit therefore let the 1983 suit proceed. Next, a professional licensing case. In Roy v. Superior Court, the Third District affirmed a public reprimand ordered by the Medical Board of California against a gynecological oncologist who permitted himself to be sexually fondled by a patient in a parking lot after they had enjoyed dinner together. Section 726 of the Business and Professions Code provides that, quote, the commission of any act of sexual abuse, misconduct, or relations with a patient, client, or customer constitutes unprofessional conduct and grounds for disciplinary action for any persons licensed under this division, close quote. The physician argued that because his patient touched him and he did not fondle her back, he had not engaged in sexual relations. Well, the court rejected this argument because the statutory definition of sexual relations applicable to lawyers, which the court borrowed and applied to doctors, provides that the term sexual relations means either sexual intercourse or, quote, the touching of an intimate part of another person for the purpose of sexual arousal, gratification, or abuse, close quote. This definition does not distinguish between who does the touching. Either way, it is sexual relations. And there was no issue in this case of what is. The court affirmed the public reprimand. Next, we turn to the law of arbitration. In Duick versus Toyota Motor Sales, the plaintiff was the target of a bizarre internet email prank that was wrapped in a marketing campaign for the Toyota Matrix automobile. The campaign involved sending an unwitting recipient emails from an unknown individual. Now, I won't try to describe the details of this marketing campaign any further. You can Google the phrase, "your other you," and go to the marketing website to see what the game is all about. That's your other you. One dissatisfied target of the prank sued Toyota for $10 million, alleging IIED, negligence, and false advertising. Toyota tried to invoke a contractual arbitration clause, but the Second District held that the purported contract was void because of fraud in the inception. The fraud occurs because the recipient of the original email could not reasonably know that by clicking on certain links, they actually were entering into a contract which contained an arbitration clause. Indeed, the terms and conditions were drafted in such a way as to entirely conceal the nature of the contract and the conduct to which the recipient was going to be subjected. The court held the whole contract was unenforceable and void, including the arbitration clause. Next, we have a health law case in Martin v. Pacific Care of California, when the 4th District held that Section 1371.25 of the Health and Safety Code was properly interpreted as foreclosing holding a healthcare service plan vicariously liable for the acts or omissions of a healthcare provider who had contracted with the plan to deliver medical care to the plan's subscribers. Section 1371.25 provides, in pertinent part, that, quote, a plan, any entity contracting with a plan, and providers are each responsible for their own acts or omissions, and are not liable for the acts or omissions of, or the costs of defending, others, close quote. The 4th District held that this language plainly precluded an action against the plan when one of its providers committed malpractice. The court rejected an argument based on the non-delegation doctrine, holding that the non-delegable duty doctrine is actually a form of vicarious liability precluded by the language in Section 1371.25. The court also rejected plaintiff's attempt to reframe its complaint as an insurance bad faith claim, noting that the complaint failed to allege any act or omission by the plan that gave rise to the bad faith claims. Instead, the only culpable act or omission was committed by the providers, not the plan, and there was no vicarious liability. And our last case involves an odd change of name. In In Re Robert Edward Fortune, the 2nd District gave us a 38-page opinion explaining why the petitioner could not legally change his name to the name of his website, which is njweedman.com. That's njweedman.com, one word. As grounds for this decision, the court cited the possibility of likelihood of confusion in the future if, for some reason, he lost the rights to the website name, yet maintained his personal name. According to the court, quote, if both parties used that name to conduct business, confusion might result, close quote. Alternatively, even if he maintained the website name, the court worried that the name might be so similar to another website name as to create confusion. Frankly, these reasons don't sound very convincing. In essence, the court seems to be holding that no one may adopt a website name as their personal name. So the court advanced another reason, that, quote, the name change would associate his new personal name with the website's advice that individuals violate the law in several respects, close quote. In particular, the website promotes legalization of marijuana and contains some advice regarding possession and use that in some states would be unlawful. Seems to me this reason isn't much better. Finally, the petitioner had sought a similar name change in his home state of New Jersey about 10 years ago. So the 2nd District's last grasp was to reason that, quote, as a matter of comity, California should not grant the petitioner the relief his home state has already considered and denied, close quote. The panel really didn't like that name, njweedman.com, although its 38-page opinion does leave one wondering about what the real standards are for adopting a name. Well, that's it for today's Kelso Report. Have a great day in the law.